I would like to make a comment here. If you have watched any of my prior videos, you may have noticed that I have discussed fraudulent transfer in the past. And you might be wondering why I'm doing it again. Well, it's because a fair number of the calls that I've been getting from people involve fraudulent transfer. People are either engaging in fraudulent transfers, have already done them, or are planning on doing them. So I thought this was an opportune moment to bring the topic up again and warn folks about this. Well, in order to understand fraudulent transfer within the context of bankruptcy, it's probably a good idea to just get a bigger picture of what fraudulent transfer is and then apply it within the bankruptcy context. And as a preface, it's important to note that this is an area of law that's been around for a very long time. In fact, the ancient Romans had a well-developed bankruptcy system and a well-developed fraudulent transfer law. This was all established by Julius Caesar, I think in part because he had a lot of debt that he had accumulated as he rose to power, and I suspect that it played a significant role in his assassination when all the senators, except for Mark Antony, stabbed him to death in the Forum on March 15th, 44 BC. So over the centuries, people have tried all sorts of ways around the strictures of fraudulent transfer law. As a consequence, in the United States today, we have at least two independent definitions of fraudulent transfer. The first captures the ancient Roman idea. So a transfer is fraudulent with respect to a creditor if it's done with the intent to hinder, delay, or defraud the creditor. So a simple example just to illustrate what I'm talking about here. Let's say you have a creditor coming after you and you have a valuable asset and you know that the creditor will want to take the asset because you don't have the money to pay the debt. So you have a bright idea of transferring the asset to your brother. That way, when the creditor comes and says, give me my money, you say, I'm sorry, I don't have any money. Well, then I'm taking that asset. Oh, I don't have that asset. It's not mine. Well, this is not a bright idea. This is a truly foolish idea. And what the ancient Romans did was they gave the creditor the right to grab the asset from the recipient. And so in the United States today, that is one definition of a fraudulent transfer. If you transfer the asset with the intent to hinder, delay, or defraud the creditor can undo the transfer and seize the asset. There is, of course, a problem with that definition if you think about it. Well, what's the problem? The problem is in the word intent. It's not so easy to know what another person intends. I mean, it's not like we can read people's minds, and the bankruptcy court does not have a team of Vulcans from the planet Vulcan to do mind melds. So instead, what the law has done is given us an alternate second definition. In this definition, a transfer is fraudulent with respect to a creditor if it's done without getting a reasonably equivalent value in exchange for the transfer. So, for example, you might have a situation where you have this valuable asset that's worth, oh, I don't know, $100,000, and you sell it to your brother for $10,000. Oh, legitimate sale, right? Well, yeah, if you have no creditors, but if you have creditors, then that's a fraudulent transfer because it wasn't a reasonably equivalent value in exchange for the transfer. Outside of bankruptcy, a creditor can undo that transfer to the extent necessary to pay the antecedent debt. Inside of bankruptcy, the trustee assigned to the case in, say, a Chapter 7 case steps into the shoes of the creditor and inherits that creditor's right to undo the transfer and seize the asset, not just to pay that creditor's antecedent debt, because the trustee is representing the entire bankruptcy estate. The trustee can undo the entire transfer. By the way, the word we use in law for that kind of undoing is avoid. It's a somewhat unusual usage of the word avoid. It means to render null and void. So if you start doing transfers, that will create a problem. Now, there's an additional wrinkle here. In the law, the transfer can have been done prior to the incurrence of the debt. This may seem a bit counterintuitive. You think, well, I didn't have any debts when I incurred that, when I did that transfer, and I subsequently incurred the debts. How can that be a fraudulent transfer? Well, this gets back to that second definition, that you didn't get a reasonably equivalent value in exchange for the transfer. Now, in bankruptcy, generally speaking, when we're talking about individual cases, those cases are filed under one of three chapters: Chapters 7, 11, and 13. In this part of the country, we don't really have any Chapter 12s, which is a chapter devoted to family farmers and family fishing operations. So those three chapters are implicated here. In a Chapter 7, the idea or the goal is just to erase debts in one fell swoop. The whole process typically takes between 5 and 6 months from the day you file the petition until the day the bankruptcy court grants you a discharge. And then those debts that are of the dischargeable variety are just wiped out without you paying a dime. Pretty extreme relief, of course, from the creditor's perspective. So there are some limitations. One limitation has to do with fraudulent transfers. If in a Chapter 7, prior to doing the Chapter 7, you did a fraudulent transfer within the 1 year pre-petition period, then you become ineligible to get a Chapter 7 discharge. So that's one of the very serious issues about doing a fraudulent transfer and then filing a Chapter 7. The second is, if you do that fraudulent transfer, the trustee assigned to the case, that Chapter 7 trustee, is empowered to go to the recipient of that largesse and avoid the transfer. So you will now alienate that person that received whatever it was that you transferred. On top of that, there is a fairly recent United States Supreme Court case involving a challenge to discharge under a theory of fraud, because one type of debt that is problematic in bankruptcy is a debt incurred through fraud. And in that case, the Supreme Court held that a fraudulent transfer can constitute fraud for the purpose of determining the non-dischargeability of a particular debt. So you create a world of hurt on those levels. There is yet another way in a Chapter 7 where things get goofed up. And this has to do with real property. Let's say you've got your home and you have the bright idea to transfer the house to your kids. Then you meet with a bankruptcy attorney and say, I want to do a Chapter 7. Oh, you created a problem for yourself. Well, you can undo the transfer prior to filing the bankruptcy case and at least undo the problem of being ineligible for a Chapter 7 discharge. But you've created another problem, and that has to do with exemptions. When you file a Chapter 7 bankruptcy, and again, in this narrative that I'm walking through right now, I'm thinking in terms of the individual case. This is not necessarily germane to a business Chapter 7. In that individual case, because debts are being wiped out, I did say that there are some limitations. One limitation is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose possessions in a Chapter 7 bankruptcy case. So one of the things we include in a set of Chapter 7 bankruptcy papers for an individual is a complete listing of all of the possessions and interests of that individual. Those assets are divided into two categories: exempt, non-exempt. The exempt stuff, the debtor gets to keep. The non-exempt stuff is fair game for the Chapter 7 trustee appointed to the case to seize and liquidate and have money to pay creditors. How do we determine what is exempt and non-exempt? Well, the Bankruptcy Code does have an exemption table, but it permits the states, if they want to use their own state tables. I'm licensed to practice in California, so we use the California tables. There are two tables in California, and we really don't use the federal table. One table is for homeowners with equity, the other's for everybody else. So let's say you had that house, you transferred it to your kids, and then subsequently you determined that you needed to file a Chapter 7, so you undid the transfer to get the house back so that you wouldn't be rendered ineligible for a discharge. What happens to the exemption? Well, this is one time in exemptions where we do have an umbilical cord that connects us back to the bankruptcy code. The bankruptcy code says that if you are trying to exempt real property and you acquired that property during the 1,215-day window immediately prior to filing your petition, then you get only the exemption that is found in the bankruptcy code, which now is about $180,000. It does change with the cost of living index. On the other hand, if you had the house for more than 1,215 days, that's 3 years and 4 30-day months, then the exemption bumps up to $699,000 and change. So that's a pretty big differential. So if you've got a fair amount of equity and you did that fraudulent transfer and you undid it, well, now your acquisition date is much more recent and you may lose the house. So there are many, many reasons why you should not do a fraudulent transfer. Now, I've been focusing in on Chapter 7. That's the most commonly used chapter for individuals and legally married couples, but there are 2 other chapters. The second chapter is Chapter 13, and that involves a multi-year debt repayment plan that's administered by the bankruptcy court. The court will appoint a Chapter 13 trustee to the case. We propound a plan. When the judge confirms the plan, then that controls. And then each month for the life of the plan, which cannot last more than 60 months, you make a payment to the Chapter 13 trustee appointed to the case, who takes the payment, distributes it to the creditors according to the terms of the judge-confirmed plan. In the meantime, you generally don't deal with the creditors. There are some exceptions for secured debts. And then at the completion of the plan, the unpaid portion is discharged. There are some possible exceptions. Now, one of the requirements of a Chapter 13 is something that's sometimes referred to as the Chapter 7 liquidation requirement for Chapter 13, or among bankruptcy attorneys, you might hear it referred to as the best interest of creditors requirement. So in order to understand that, remember in Chapter 7, you might lose possessions. The Chapter 7 trustee will take the non-exempt assets and liquidate them. Well, in Chapter 13, you keep all your possessions. No trustee is going to take any of your assets. But we still go through the exercise of listing all of your stuff, dividing it into exempt and non-exempt categories, because whatever the dollar value is of the non-exempt assets is the amount the creditors would have gotten if you had done a Chapter 13 or Chapter 7. So the minimum you can get away with repaying in the Chapter 13 is the dollar value of those non-exempt assets. Well, there is one other factor that comes into play. Suppose you did fraudulent transfer and then you were to file a Chapter 7. If the trustee were to undo that transfer, remember, avoid the transfer and seize the asset, then the creditors would be paid out of the proceeds of the liquidation of that asset. So that also goes into the Chapter 7 liquidation requirement. As a consequence, you might end up with a very large plan payment because you did that fraudulent transfer. So even in Chapter 13, where generally a Chapter 13 trustee will not mount an avoidance action to avoid the fraudulent transfer, it still will affect you. And then I mentioned that there's Chapter 11. Normally we think of that as a chapter for businesses, but if your debts are too large in a way that can be made precise to qualify for Chapter 13, and your income is too high for Chapter 7, then the next stop on the bankruptcy train is Chapter 11. Generally in a Chapter 11, there is no Chapter 11 trustee, unless it's under something called Subchapter 5. If there's no trustee, then I guess there's no problem with fraudulent transfer, right? Well, no, that's not correct. It turns out that if you are in a Chapter 11, you become a quasi-trustee called the debtor in possession. And you have all the rights and powers of a trustee, but you also have the obligations of a trustee. So if you did a fraudulent transfer prior to filing the bankruptcy petition, then you have the obligation as the debtor in possession to undo that fraudulent transfer and seize the asset to be put into the bankruptcy estate for the benefit of all the creditors. So there's this sort of ripple effect throughout any of the chapters involving fraudulent transfers. The long and short of it is, please don't do that before you file. And if you call me and say, well, I'm planning on doing that, I will tell you that's the absolute worst thing you can do in anticipation of filing a bankruptcy case. And if you have done it, then, of course, we need to talk about some pre-bankruptcy planning to avoid this problem. The final thing I'm going to say about all of this is there are a couple of ways that a trustee or a debtor in possession can avoid a fraudulent transfer. The first is appealing to the fraudulent transfer statute in the bankruptcy code. The fraudulent transfer statute in the bankruptcy code does have what we might refer to as a statute of limitation. It's measured from the day we file the bankruptcy petition. The trustee can go back 2 years and avoid any fraudulent transfers that took place during that 2-year window. But the bankruptcy code also allows the trustee to piggyback on non-bankruptcy fraudulent transfer statutes. In California, we have what used to be called the Uniform Fraudulent Transfer Act. It's now referred to as the Uniform Voidable Transfer Act, I guess because people were offended by the term fraudulent, but it doesn't really change the content of the statute, just the label. And that has a different look-back period. Now, that's not measured from the day you file your bankruptcy petition. It's measured from the day the trustee files the complaint to initiate the avoidance action. And there, the trustee can go back 4 years to avoid any fraudulent transfers with additional time up to 7 years if the transfer couldn't have been readily discovered. What do we mean by readily discovered? Well, it was recorded with some governmental entity, an appropriate governmental entity. For example, you transferred the house, you recorded it with a county recorder's office. And yet another thing that the trustee can do is piggyback on the IRS's statute of limitations if you owe the IRS money on the day you file a petition. And that statute of limitations goes back 10 years. One final little note on the statute of limitations. The bankruptcy code itself, in its fraudulent transfer avoidance statute, also allows the trustee to go back 10 years if you have transferred an asset to a self-settled trust of which you are the beneficiary. So the long and short of it is, don't do it. And it's a little frustrating, a little sad, especially when I get these calls from usually men that are so pleased they think that somehow they've really found the magic bullet, that somehow nobody's ever thought of this before, and they have just stepped into a landmine. That's what I have to say about fraudulent transfer in bankruptcy.